Good morning. Welcome to our webinar for today, titled Demystifying M&A in Croatia. Obviously, those of you who have joined us today, and of course anyone watching the video online, will no doubt be aware that there are certain peculiarities in the Croatian laws when it comes to M&A, and that standard international contracts based on common law cannot be used unproblematically. At least that's my perception. I'm sure Mojme and the Osterman team will correct me very shortly. But anyway, to take us through the idiosyncrasies of Croatian M&A today, we are joined by leading independent Croatian full-service law firm, Osterman and Partners. I'm James Wood, one of the editors at the Legal 500, and today we will hear from Barbara Vichka, a senior associate with Osterman and Partners. Barbara is an experienced corporate and M&A lawyer with particular expertise in competition law. She advises clients coming from various industries such as construction, retail, and telecommunications. And I'm sure she does a lot else that I've missed. But Barbara, perhaps could you say a quick hello so people know who you are?
Hello, this is me. I'm Barbara, and I will hear from you shortly in relation to competition issues with this transaction on Croatian markets.
Well, thanks for joining us. We will also hear from Senior Associate Mariana Solder, Senior Associate at Osterman & Partners, of course. Mariana has more than 8 years of experience advising clients in complex corporate and capital markets matters. She was a senior team member in many landmark transactions in the Croatian market, which perhaps you can give us some details of in just a second. Mariana also leads the employment law practice at Osterman & Partners. Mariana, welcome.
Hello, everyone.
Excellent, thank you. And leading the session today, we will have the firm's founding partner, Mojme Osterman, described by his clients as a complete star, a gentleman and a great lawyer, and an excellent and tough negotiator. Mojme has more than 20 years of experience advising local, multinational companies and financial institutions on high-profile corporate and M&A transactions across industries, as well as on banking and finance and capital markets. Mojme was a team leader in some of the most complex cross-border deals in Croatia and was recognized for innovative solutions to seemingly intractable challenges. For the second year in a row, Mojme has been named leading individual in the Hall of Fame for Corporate and M&A in the Legal 500's Croatia Guide, and he is one of only 2 lawyers in this practice area. He is recognized as one of the leading disputes lawyers in Croatia also. So Mojme, do you want to say a quick hello before we pass over to you?
Good morning, hello.
Thank you. Okay, look, before I pass over to Mojme to get us started and get the benefit of the Osterman's team's expertise in the field, I want to encourage you all in the audience to contribute. So if you do have any questions relating to Croatian M&A, this is a wonderful opportunity to hear from the experts. So please do use the Q&A function on Zoom to submit your questions. We'll try to get around to as many as possible. So we do want to hear from you also. Okay, with that said, I will pass over to Mojme to kick us off. Mojme, please.
Dear James, thank you. It's really a privilege and pleasure to have this webinar in collaboration with Legal 500. We hope you will enjoy our presentation. In presentation, we will go through some of examples that we have in our past years. Just briefly, I would like to point out, given that some of you may be looking at this presentation at a later stage, that it's possible that this presentation will not be up to date at the moment when you will be seeing it, given that, for instance, this Saturday, the new Competition Act or its amendments were put into effect. Also, you have to take into account that this is not complete information. Unfortunately, we have limited time, and therefore it's impossible to include all the details which may be specifics. In addition, we are qualified as Croatian lawyers, not as English lawyers, so you also have to take this into account. So today, first we will go through the regulatory regime. Mariana will take you through Takeover Act. Later on, Barbara will tell you something about competition. So what you as investor have to take in mind when you are contemplating a transaction in Croatia. Afterwards, this is my part, we will be discussing international standard contracts which are commonly applied in Croatia and which contracts are founded in common law. And therefore the question is, how such contracts blend in Croatia. At the outset, I will say that Croatian market has been very dynamic in M&A before COVID. So in late 2019 and early 2020, we had really a lot of transactions pending. Then with lockdown, of course, everything was put on hold. We have a lot of new practice on MAC clauses caused by COVID. We also had big earthquake in Zagreb actually just when the lockdown began. So all of these gave us some new insights on how to structure transaction in difficult times. Very soon after lockdown, when investors realized that there is actually light at the end of the tunnel, most of the transactions were continued and they were closed either by the year's end or at the beginning of this year. It should be noted that despite COVID, it was an excellent year for IT sector. It proved fully resistant to COVID. So we had a landmark sale of Nanobit, so it was $150 million sale to Stillfront. After that, we had minority investment from Silversmith Capital Partners into Microblink. And later on, Croatia was, its video game developer, was acquired by Devolver. Apart from that, as most of you are aware, in Croatia, we have a seat of biggest regional company, Fortenova Group, which is formerly known as Agrokor. It's been restructured, and as such, within its business plan, it has to sell non-core assets, which is substantial. So last year, they sold construction part of business, in actually which we advised the buyer. They sold touristic tour operator and one hotel resort. And in first quarter of this year, they signed a sale of their entire frozen division, which includes not just Croatia, but also Bosnia and Serbia. It was remarkable 650 million euro sale. It's expected to be closed in September, in third quarter. So what we can expect that Fortenova will continue sending new assets on sale, maybe also from core business. We've seen in news that there is great interest for agricultural business, which may be also put on sale. So generally, we are very optimistic in what is yet to come for Croatian market. Now we will move on to our presentation. First, we have Takeover Act. So Mariana, the floor is yours.
Mojmir, thank you for this nice introduction. I'm Mariana Soldo-Kubat, Senior Associate at Osterman & Partners. First of all, I must say I'm glad to see such an interest in today's webinar. It's always great to see people interested in the Croatian market. My task today is to briefly present you the things you, as a potential acquirer, need to consider before starting a transaction in Croatia, before acquiring shares in Croatian companies. With that in mind, I will give you a short high-level overview of the differences between acquiring shares in private company and acquiring shares in publicly traded companies, with focus on something which is related to the acquisition of shares in publicly traded companies, and that is the Takeover Act. My colleague Mojmir will actually then elaborate more about things which are, let's say, more interesting for M&A in general, but my part is also something you definitely need to know before starting a transaction in Croatia, since this is something which could cause you additional costs, potential liability for administrative offenses, and other legal consequences. So let's start with the overview. Could we go? Okay, thank you. So What is the first thing to consider before starting a transaction in Croatia? Well, the first thing to consider is whether this company you are interested in is private company or publicly traded company. Publicly traded company is company listed on the regulated market of Zagreb Stock Exchange, and private company is every other company which is not listed on the Zagreb Stock Exchange. Now, why is this important? Well, because of the differences between legislation regulating M&A of private companies in Croatia and the legislation regulating M&A of publicly traded companies in Croatia. Okay, could you take me to the next slide? Because on my next slide, I have listed the most important differences. I won't go through it, but I will say that maybe the most important difference is the fact that if you are interested in acquiring shares in Croatian company whose shares are publicly traded, then you need to take into consideration special rules concerning the takeover of publicly traded joint stock companies, which are stipulated in the Takeover Act. Since this is the most important thing to consider, I made a short overview of this act on the following slides. However, before going through these slides, let me tell you something about how to recognize if your company is publicly traded. So on my next slide, as you can see, I wanted to say something about regulated markets. So could you please take me to the next? Thank you. So as I said at the beginning, company is publicly traded if its shares are listed on the regulated market of Zagreb Stock Exchange. A regulated market is trading segment managed by the Zagreb Stock Exchange. And as you can see on this slide, it is divided into three categories. You have prime market, official market, and regular market. The main difference between these categories are actually the requirements which are set before the issuer meaning the company whose shares are listed, particularly in relation to the transparency. That means that when thinking about acquiring shares in a Croatian company, after you determine that this company is publicly traded, which you can actually do by checking the Zagreb Stock Exchange website, you should take into account the market on which this company is listed, since this is something which will affect the transparency requirements for the issuer, and which will then affect actually the risk of your investment. For example, prime market here is the most demanding market segment with regards to the requirements set before the issuer. And if you're thinking about acquiring shares in company listed on prime market, then you will have a large amount of information about this company publicly available on the internet or websites, unlike the situation when you're interested in company listed, let's say, on the regular market. After you determine that your company is publicly traded, then you need to take extra care, because then your transaction will be regulated by the Takeover Act. The Takeover Act, could you go to the next slide, please? Thank you. So the Takeover Act has implemented the directive on takeover bids, and it regulates mandatory takeover bids for the shares of joint stock companies. Meaning, if you're planning to acquire shares which represent more than 25% of voting shares of the target company, then you will be obliged to announce a mandatory takeover bid. As of this moment, when you as the acquirer are under the obligation to publish the takeover bid, up until the expiry of this offer, you may acquire the shares only through the takeover process. So as you can see, this is something you really have to bear in mind, and therefore on my next slides, we are just going to go through quickly through the main aspects of the mandatory takeover bid. So on my next slide is the first important thing to know. I indicated the price. Well, in general, the price in the takeover bid, the offered price for the shares may not be lower than the highest price paid for the shares the prior year by the bidder, and the average weighted closing price of the target shares during the last 3 months, of course, if you're dealing with the liquid shares. The purchase price for the shares in the takeover bid can be paid either in cash, shares, or combination of both. And in case of non-cash and combined offer, the bidder is obliged to submit a cash offer as an alternative. Another important thing, which I think that you as the bidder might be interested in, is the scope of due diligence in case if you are buying the shares in publicly traded company. So I will tell you something about it. As you can see from this slide, the Takeover Act does not require the target to allow due diligence to be conducted, but the target's management may permit due diligence by the bidder if it deems this to be in the target's best interest. I would say that this is actually the difference between friendly and hostile takeover, because in a hostile takeover, the management of the target company is against the takeover and will probably not allow the due diligence. And on the other hand, in a friendly takeover, the target company management will probably be more willing to allow due diligence. However, if the management allows the due diligence, the problem can arise from the fact that the bidder, in that case, might have the access to the inside information, which is strictly regulated by the market abuse regulation. This is a regulation which also applies only to publicly traded companies and not private companies. And in connection to that, another important question or thing to consider is the case is actually at what moment of the announcement this information that someone is interested in buying shares in someone's company should be publicly announced, and should actually the management board announce this information from the very beginning, like from the first time they actually maybe heard someone talking about thinking about acquiring shares in his companies. For example, here in Croatia, we had one very famous hostile takeover bid, and I think that this was at that time one of the rare cases of hostile takeover bids in Europe. It was a takeover of the largest pharmaceutical company, Pliva, where Pliva's management, after the company Actavis sent the bid, which at that time wasn't publicly available, Pliva's management found another interested buyer, which was Bar Pharmaceuticals. In the end, Bar acquired Pliva's shares, and I think the difference between the offered price at the end was like only 5 kunas or something. However, after this takeover process was finalized, HANFA, as a regulating body in Croatia, issued an interesting decision in which it determined that Pliva should have announced that the Actavis was interested in buying Pliva's shares and in conducting due diligence process as soon as they have received Actavis offer, which was actually something like 3 months prior the publication of Bar's offer. And HANFA decided that this information could have had a significant effect on the prices of Pliva's shares. And this opened the question about damages. This is something which is actually really interesting to talk about, so we can discuss it like later, maybe if you will have any questions, since I really don't have that much time left for my presentation, and I have some other things I want to mention before the end of my part of the presentation, such as the duration of the takeover in case of a mandatory offer, since I think this is something you also need to have in mind if you're thinking about acquiring shares in Croatian companies. So, as you can see from this slide, the takeover in case of mandatory offer lasts at least 3 months, and main stages are indicated here on my slide. I will not go through it, but maybe the most important thing here to know is that the regulatory body which decides on the application for the approval of the announcement of takeover bid is Croatian Financial Supervisory Agency, and that after the acquiring of 25% of voting shares, a bidder must file a request for the approval of the announcement of this takeover bid within 30 days after this threshold is met. Of course, even when thinking about this deadline, you have to bear in mind some specific situations when, for example, you need prior approval of some public authorities, such as competition authority. However, this is something Barbara will now give you an insight. So I will leave you with Barbara, who will tell you something more about it. Of course, if you will have any questions about my section, please feel free to ask them. I suggest you to type them in the chat, and we can discuss them later. So this is it. Thank you for your attention. Barbara, Please.
Thank you, Mariana. Thank you for your overview of the Takeover Act. I will get back to some of your slides a few times during my presentation, as that will be, there are some very important provisions also related to the competition. As already stated by Mojmir and Mariana, my name is Barbara Vričko-Hrabar, and I will briefly provide you with some general information and possible issues that may arise with respect to the competition regulation in Croatia. I will try to be as brief as possible because I know this is not the main topic of this session. Maybe there will be some other sessions just related to the competition. As Mariana already made this main division between private companies and publicly traded companies, and that's the first question you have to ask yourself about your target. There's also a second question strictly related to the type of the target that is subject to your transaction. And that is actually, is the target regulated in these specific sectors stated on this slide? I really do believe that these specific sectors are specific all across European Union, but also worldwide, as they are usually overly regulated and they all have some specific regulatory bodies for those sectors. This slide is important in the transaction part because you need to have in mind that when you're dealing with companies from these industries, you will always have some kind of pre-approval or at least notification to those authorities, which will then be probably before signing. And then later on, you will have notification to Croatian Competition Agency. I will call Croatia Competition Agency CCA during this part of my presentation. So just for you to have in mind this abbreviation, we also call it AZTN in Croatia, but as I've seen a lot of investors from foreign countries, I will be calling it CCA. The most important thing, I will not go through all of these authorities. The most important thing for you to remember is that there are some specific authorities. You will need their prior approval, but the authority that will decide about competition clearance at the end will always be CCA, Croatian Competition Agency. Out of all these sectors, I will just point out media sector as it's a bit specific because in that sector you will not be obliged to think about thresholds because you will need to notify CCA agency either way, notwithstanding the thresholds, if the thresholds are met or not. We can go on the next slide. Thank you. So before we go to this slide, and just for you to know, this slide is strictly technical, but I will give you some context to it. But before that, I would just like to say that I went briefly through the list of participants, and I have seen some investors that are not EU based. So just a short note for you, if you had any kind of transactions within European Union, then you should not be expecting any new concepts and any new issues here on Croatian market, because we really are fully aligned and harmonized with the EU regulation, or at least we're trying to be in practice. And I think that CCA is doing a good job there. And for my colleagues from Croatia, I've seen a number of you on the list. Just to have in mind that actually this Saturday, new amendments of the Competition Act came into force. We will not go through all of these amendments, but just for you to have in mind, most of them are technical. But with these new amendments, we are, I think, now fully harmonized with EU regulation. So this slide on the left actually tells you about the type of transactions that are caught. Of course, most of the transactions are caught, most mergers and acquisitions. Joint ventures are always very interesting, but as just competition is not subject to this session, we can maybe circle back to these joint venture and the way to calculate their thresholds in the Q&A part. So for the foreign investors, it's just important to know know, as in all jurisdictions, concentrations are not forbidden and are not bad just per se. They will be considered to be bad if they're disrupting the competition on the market, if they're strengthening someone's dominant position. And at the end of the day, agency always takes into account that if the concentration has negative effect on the consumer. What is considered to be an undertaking? I also believe it would be much more interesting if we can go through this via Q&A if you have some specific questions. But just here, I put little exclamation point here near company E for you to know that with these new amendments of the Competition Act, actually we have this stated right now. We didn't have it stated before. And to all of my colleagues that are dealing with competition, they're well aware of this diagram. But with these amendments now, we really have this entire diagram implemented in here in Croatia. We can go on. Okay, thresholds. Before I present you the thresholds here in Croatia, I would just like to point out that for you to have a bit scale of our market in 2019, and the 2019 is the last year for which we have these informations, as CCA agency has a deadline until June to present information about 2020. We have in 2019 21 notification to the CCA. Out of those 21 notification, which I believe is not a high number, there are only two cases where CCA decided to further assess concentration and go in this second phase of concentration proceedings. All other concentrations were cleared. In relation to that, these thresholds are very, I believe, very applicable to our market, and they are normal for our market. Some of our clients were a bit surprised that the turnover on domestic market is so low, but for our market that is not a low. 13 million euros is a lot of a turnover to be made on Croatian market, and the total world turnover has to be somewhere near 134 million euros. Most of the transactions don't even get to that threshold, but for investors in media sector, have in mind that you shouldn't even care about these thresholds because you will need to notify CCA no matter the thresholds. We can go on now. So this is, in my opinion, one of the most important questions when dealing with competition transaction-wise, because it's very important for timing, it's very important for drafting CPs, and it is very tricky when we are talking about publicly traded companies. So it seems as the article is quite straightforward and you would not expect much issues there. You need to notify CCA about your transaction after the conclusion of the agreement or announcement of a public bid or after acquisition of control. When dealing with private companies, the question of timing for notification will be quite simple. You will usually notify CCA agency following the conclusion of the agreement. Maybe in some cases you will use this option stated as or on this slide to do it even before signing of the agreement, and then you will have to prove that both sides are really willing and have a good faith in concluding this agreement. And you won't encounter much issues there. You will put this as a CP for the closing. CP for the closing will of course be a decision of the CCA on the clearance of the transaction, or merger or acquisition. But when you're dealing with publicly traded companies and mandatory offers that were already discussed a bit by Mariana, you will actually be pushed to use this or part of our legislation, where you will not be able to notify the CCA agency after the announcement of a public bid, because that would be forbidden by the Takeover Act, basically. So you will always, in that case, you will always need to go on this option to notify the CCA agency before you are before you can go and announce your public bid, and even before you submit your request for HANFA to approve your public bid. You have two issues there. First issue, and just for our colleagues that are in practice, actually, this is not, and I believe they know that this is not just an academic debate on what article to use. This is actually a very specific issue here on Croatian market. We had some clients dealing with that, and finally we have even some practice in relation to that, but I will get to the practice of CCA on this question. So you will have two issues when you have publicly traded company and mandatory offer. First issue will be the fact that you have to prove this good faith intent from both parties. So you will have to prove on your end a good intent that you will actually publish your official bid, and you have to prove that the other side will accept your bid. Of course, as Mariana gave you a bit insight into this Takeover Act, that will be impossible for the target. That will be impossible for the target because it is explicitly forbidden by the Takeover Act. That leads to the issue that CCA will not be able to say, okay, legal requirements for applying this article are fulfilled and I can render a decision. CCA will have to dismiss your notification. And that leads to the second problem, and the second problem is related to the fact that before you publish your official bid, you need to get the approval of HANFA. And HANFA will not give you an approval before you have the approval of CCA. So it's a kind of a catch-22 in Croatian legislation. Finally, we have some opinion of CCA in relation to that, because there was one case in 2019 where there was acquisition of Luka Ploče, Port Ploče, by one company, and actually they submitted their notification of the concentration prior to them receiving approval from HANFA. CCA, of course, as I said before, rejected their notification, stating it cannot decide on it because legal requirements are not met. And then HANFA received the entire documentation as well as that decision and said, okay, I can't do anything else but accept this as a decision from the CCA, and HANFA actually allowed this bid and approved publishing of the official bid. Of course, this cannot be a permanent solution to this problem. As I believe you're all eager to hear from our managing partner, and I know he's quite keen to start with his part, I will just conclude briefly. I took too much time already. For my Croatian colleagues, of course, you know there's a two-phase review. For the investors, two-phase review is in the most European countries. I don't know any country that there isn't a two-phase review. It's also like that in Croatia. If everything is fine and there is no forbidden concentration, you will get first instance decision in 30 days. If CCA agency thinks that maybe there will be some effect to the market, we will go to the second phase, and then you will receive the second instance decision in 3 or 6 months, depending on the circumstances of that transaction. Mojmir, the floor is yours now.
Mojmir, you're on mute. You need to unmute yourself. Right. Happens everywhere.
Sorry. Yes, thank you. I clicked, but it didn't work at first. So thank you, Barbara. We are now moving to the contracts. So the first question I would like to raise is, what's the biggest difference between typical international standard type of contract, which is based on English common law, and Croatian contracts? Well, the size. So Croatian contracts are usually up to 10 pages long, whereas common law contracts often have up to 100 or even more pages. The reason behind this is that Croatian law, like all European continental law, is codified. On the other hand, English law is founded on wealth of precedents. So in Croatia, you don't have to even make a reference to certain provision of the law. You just put in the general provisions that the parties want to agree, and you could have implied reference by law on many regulations. This is actually the reason why supporters of English law would say that continental system, continental type of contracts is not solid, that it does not prove certainty to parties, because they would say, yes, surely it's 10 pages long, so I can read it very, very quickly. It may be also very comprehensive, but at the end of the day, I don't have full picture. So in order to know what I agreed with my counterparty, I have to take thick textbooks to see what's also within the law, to understand what is the contract we just made. At English law, you have 100-page contract, but it contains the full relationship with the parties. So there is no reference to the law which is implied, except in some very rare cases. The second reason why English contracts are thicker than European ones is that under English law, there is no duty to disclose. So what does that mean? I'll give you an example. So let's say we have a guy who go to the bar and he doesn't meet a girl. He meets with another guy. It's not a romantic story, it's business story. They start talking about football, and after a few pints, the other guy from the story says, well, you know, I own Aston Martin, which was in James Bond movie Goldfinger. And you say, wow, I wish I had such a car. And the other guy says, well, actually, I own it for a couple of years now. And if you're so keen in owning it, I'm happy to sell it. And they made a bargain. They agree on 20,000 quid. The next day, our guy from the story realized that the car doesn't work. So it is indeed 1963 model of Aston Martin, but its engine is demolished. So our guy goes to the other guy and says, you tricked me, you fooled me. And he says, well, I didn't. I told you it's 1963 model, and it is. You never asked me if the car is working. In Europe, you wouldn't have a problem, because in Europe we have a principle of good faith, which says that you ought to disclose if the good which is subject of sale is malfunctioned. Whereas in England, there is a principle of dealing at arm's length. So basically, each of the party is on its own. They are at arm's length, meaning you are there, I'm here, we're not close. It's not because of Corona, it's just that we treat each other as independent. This is why this principle is also applied slightly differently, but with the same rationale in tax law. So the buyer should be aware, caveat emptor. So this is the reason why in English contracts, you will ask a seller to provide you with a set of warranties, representations and warranties, under which you could rely. And this set usually have more than 20 pages. So if you now dive into the specifics of English law, the first we have is representation. Representation is a statement of fact which is addressed to the party misled, which is material and which induces the contracts. So the most important of this element is that this is something which induced entry into the contract. In our former case, this would be that it's not any car, it's 1963 model of Aston Martin. So this is what induced you in the contract. However, the seller will want to limit its liability for its representations and warranties, and this is why it will always seek to get protection by buyer acknowledging that it itself performed a due diligence, that it had sufficient opportunity to read any and all information available, that it obtained all information and raised all questions it had, and that it's not aware of any matter which is inconsistent with any of the warranties. I will just briefly note that in our former example with the car, that in English law, the position has changed in 1979 with the Sales of Goods Act. So basically, even in England, you could not be fooled by buying a car which is not working. But under the common law, the principle remained the same. So maybe our example is not applicable any longer, but the principle it is. So on the other hand, the buyer will want to say that it relied on all representations and warranties provided, or as a possible compromise that it indeed conducted its own legal due diligence, but that it also relied on representations of the seller. So this example was to show you why such clauses which are customarily are provided in the contracts, in order that the seller could say that he did not induce you because you had opportunity to review, and if you applied your due diligence, you should be aware of what you're buying. Next question is, what are the warranties? So a warranty is a contractual statement that a certain state of affair exists. As such, warranty is a term of contract, but not any. In English law, there are terms which go to the roots of the contract. These are called conditions, and warranties are of subsidiary importance. So, for instance, in a sale of a car contract, condition would be that the subject matter is indeed a car and not a model of a car, whereas a warranty would be that representation would be that it's 1963 model of Aston Martin, and warranty would be that it's, let's say that it has 280 horsepower or that it's silver color. Why is that important? Because in English law, you have different remedies. So for misrepresentation, innocent party may set aside contract. For warranties, it may only claim damages. And for conditions, it can also set aside contract. But the principle is slightly different, because with misrepresentation, the party can set aside it both retrospectively and prospectively, whereas for conditions, only prospectively. This is why the clients will always want to have representations and warranties classified as the warranties. So what I failed to mention is that, as we said, both representation is a statement of fact and warranty is a statement of affairs. So this is very similar, as both are statements. And actually, each statement may be classified both as the representation and the warranties. For instance, the accounts were made in accordance with international financial reporting standards. This can be both representation and the warranty. The key question is, in negotiating the contract, whether respective statement induced the buyer to enter into the agreement. So the lawyers would sit with the clients and they would basically go through all the statements which were provided, and then they would ask the buyer, okay, which of respective statements actually did induce you to the contract, and they would be classified as representations, whereas the other one of subsidiary importance would be classified as the warranties. Of course, the seller will be less inclined to provide representations because he or she does not want the contract to be subject to rescission. And therefore, in standard contracts, what you can see is that you have a heading which says representations and warranties, where in effect in the body of provision you have that the seller warrants to the buyer, and then further on that the seller further warrants. So there is no reference to representing. And the fact that you have heading representation would not qualify any of the statements below to be representations. They would be all perceived as warranties, so the party, so the buyer, would not have right to rescind the contract. It would just be entitled to claim the damages. So what are the purposes of warranties? It's twofold. At first, it encourages the seller to disclose any shortfalls of assets, because if it doesn't disclose, well, then they work as subsequent purchase price adjustment mechanism, as if the warranty is not true or accurate, then the seller will have to put the buyer in a position as if they would have been. Finally, we have indemnities. This is something that is also standard in contracts. It's very similar, but it's also very different. So indemnity is a promise to reimburse the buyer. So it's undertaking. Such liability is in principle known, and as such is limited and it's not general. So for instance, in a transaction, let's assume the parties agreed on a sale of a company. They agreed on EBITDA multiple, but there is one important litigation. Let's say that it's a pharmaceutical company and that someone is contesting the, let's say, vaccine for COVID. It makes a huge difference, and it's really difficult to calculate the purchase price with this litigation being lost or with this litigation being put aside. So what do? You say that the purchase price is as is, based on EBITDA multiple, but if the company loses litigation, the seller will indemnify the buyer or the company, as they agree, for the full amount of awarded damages. Similarly, is for tax. Tax is one of the most common indemnities provided, and in US environment is very popular. In Croatia, it's not that applicable because, to our knowledge, in US there is a rule that the owner of real estate is liable for if it's polluted. So even if buyer acquires a real estate from the seller which polluted it, and if the buyer was not aware of real estate being polluted, it would be fully liable to basically cure the land, and this is why it's very customary to put environment indemnity in US contracts. So what's the difference between warranties and indemnities? Compared to warranties, indemnities cover future events. So warranty says it's they would say that it's a silver car, that it has 5 gears, that it runs on gas or diesel, whatever. So this all relates to past and present events, or that the company does not have disputes. On the other hand, indemnity covers future events. So if something occurs in future, I will reimburse you. From structural point of view, this is important to note, as in case of misrepresentations and breach of warranties, there is a breach of contract. In indemnities, there is no breach of contract. So if this event, if this condition is fulfilled, the buyer claims performance of contract. This structural difference is important to note, as given that there is no breach of contract, there is no duty to mitigate losses, and rules on remoteness also do not apply. Later on, we'll come to Croatian law, and then we will also point out some further differences. Quick example of indemnities clause. So it's a promise the purchaser undertakes to pay following a decision by the relevant authority. So now we move to Croatian law. So in Croatia, we have Code of Obligations, which is very similar. It's founded on Austrian Code of Obligations, and it's very similar to Germanic part of European group. So even though it's rather different than the English contract law, it should be said that each term in English law, as we discussed, that terms are both conditions and warranties are terms, whereas we have rights and obligations. But still, given that each term rises a contractual obligation, we could well say that position to that end is relatively similar. So what are the obligations of the parties under Croatian law? We, of course, looking at sale and purchase contracts. So the fundamental obligation is to hand over the goods or pay the purchase price on the side of the seller and take over the purchase goods. So this would be fundamental conditions, which would be classified in English law as promissory conditions. And after the sale, we have liability for material defects, and we have liability for legal defects. These are, we could say, terms of subsidiary importance, which we would qualify as the warranties. On number 3, we have something which is basically, in essence, a product guarantee. So we will be now discussing liability for material defects and legal defects. And later on, we will explain the position of representations. Representations as such do not exist in Croatian law, but we will come to that a bit later. So in Croatian law, we have a catalog of material defects which are implied by law. I will only point out to the number 3, which is something that we usually do. These are all the qualities and characteristics that we put in the contract explicitly. Now we move to the interesting part. Earlier there was a question on liability. We will have limitations at the end of this section, but now we will talk about exclusion of liability, which is implied by the law. So the seller, like in our example, shall not be liable for defects which were familiar to the purchaser or which could not be unfamiliar to him unless the seller specifically warranted for a particular defect. In example with the car, if you are testing the car and you hear some noises and the seller says, don't worry about it, it's the road, or the window is open, so this is why it's so noisy, the car is fine. In such case, even if you could have realized that something is wrong with the engine, the seller would be liable because he provided specific warranty. On the other hand, if you were aware that the car is not working because you were, let's say, professional car dealer buying used car, then you cannot have seller liable. And why is that? Because of principle of good faith. So you cannot sandbag a seller knowing that a certain asset has malfunctions. You're making good bargain, you're buying the car or whatever you're buying for a cheap price, and then you go to the seller and request that he repairs it. In US and UK, this is possible in principle, and this is why sometimes they have a special even clause covering for it. Now we can move. I will also say that this under number 2 is very important for due diligence, which we will address later on. So if the buyer is conducting due diligence, he might be aware of certain defects. And if the buyer's due diligence team discovers any shortfalls, the buyer should discuss it with the seller, and it should either request specific warranty or indemnity based on the findings of due diligence, as otherwise the seller will not be liable. Remedies for non-performance. So we said that in England it's not the same whether it is a representation or warranty, as under warranties you cannot terminate the contract. Under Croatian law, you can terminate the contract no matter how you classify the statement. It also does not matter whether the statement was material or whether it was inducing to a contract. So as long as the other party did not perform its obligation, you have to first request performance, unless timely performance has been determined as an essential term of the contract, in which case contract is immediately terminated. But other than that, the contract will be terminated unless immaterial part of obligation has not been performed. So this is one big difference between the legal systems. So we said that representations as such does not exist in Croatian law, except for fraudulent misrepresentations, which is under English law also known as mistake, a deception. So if one party causes other party's mistake or keeps him in mistake with intention they conclude a contract, the innocent party may claim the contract being void even if the mistake was not material. So we discussed what are the differences between warranties and indemnities under English law. We will now also have a look at Croatian law. Actually, it's rather similar approach. In Croatian law, it also offers opportunity for purchaser to claim performance rather than breach of contract. And for that reason, it's much simpler to enforce indemnity than the warranty, as in case of the warranty, you need to prove a breach. And let's say that if there is a breach of warranty on accounts, for instance, that the accounts were not made in accordance with international financial reporting standards, you would need expert witness to basically to evidence it, and sometimes this is not even with 2 or 3 witness experts easy to prove. The second reason why proving breach of warranties is difficult, as you have to prove what is the amount of damages. With indemnities, you have a sum which has been adjudicated to the other party, so you don't have to deal with amounts. With warranties, you need to. And finally, as we said, under indemnities, in principle, there is no duty to mitigate damages, which is the case with the warranty. So, for instance, if let's say that you bought a company within agricultural business, and that, I don't know, the ownership or some of real estate has been disputed, well, then you have duty either to reduce the costs so that you will not order I don't know, the crops you wanted to crop, or otherwise you should obtain a lease of adjacent real estate. So these are the questions which might be disputed under warranties and not under indemnities. So in essence, if you have option, you should always opt for indemnities. Now we move to the last part of our presentation, and that is limitations of liability. I recall when I started my career some 20 years ago, the limitations were very scarce and general, but in the last 10 years, the limitations became one of the most important parts of the contracts. They tend to be very aggressive recently, and we will now glide through basically general principles within limitation sections. So there are 4 layers. First, we have a claim protocol, which we will deal in next. We have de minimis, so you have to have, you cannot claim any amount. It has to be above certain level. Then there is a cap. I'm liable only until up to that amount, not above. And of course, there is a time limitation. You cannot come and claim damages at any time, but only until a certain point of time. So claim protocol. So purchaser will have to file a notice of claim. It will have to be submitted promptly. So this is the first time limitation. Aggressive sellers will want 30 period. So as soon as you become aware, you have 30 days to notify. In our practice, this is nearly impossible because after the transaction is closed, when so usually you have M&A team and then you have operations. When operations take over, they are not aware of complex M&A contract which led to a transaction. So when they notice that there is some problem in the company, it takes time for things to go from operation team to the top, and then from the top to the M&A team, which dealt with the transaction. And usually this 30 days expires very quickly. So what we advise clients is never to go below 60 days. 3 months is something which is, I would say, market practice. And if we have very aggressive seller and if the buyer is very keen to acquire the company, then we introduce business days instead of the calendar days, because 30 business days is 40 calendar days, and that gives you some extra space, which might be just what you will need. Of course, it has to be in writing, and then there is a final loop at the end. It has to contain such material details which will enable the seller to know what is the basis of the claim and estimated amount of losses. The reason behind this is not, you shouldn't be fooled, it's not that the seller has all information, but that the purchaser may not say to the seller, well, you knew it, we filed it in time, because usually when operation team will discover something, they will probably discuss it with operational team on the side of the seller, but they will not send this information in required form, and then the seller will dispute it. This is why this third point is so important. And of course, you will have the limited time to initiate legal proceedings. It goes from 2 to 6 months. Again, less than 3 months should not be accepted because it takes time to prepare a case. So after you file a notice of claim, maybe you will wait some time to get answer, then you will maybe start talking, and once you engage lawyers will need at least a month to draft a claim. So 6 months is something that we would strongly advise, but 3 months is something which is theoretically also doable. Time limitation. On the left side, you have statutory claims. In Croatia, statutory claim for taxes, it's 6 years plus year in which offense occurred. So if the transaction which was booked was in December, it's 6 years and 2 weeks, but you never know whether it will be January, in which case it will be 11 months. So this is why we usually say 7 years. Commercial claims are 3 years. General claims like unjust enrichment and damages are 5 years. But in contracts, you will get 3 years if the seller is purchaser friendly. The aggressive sellers will claim, well, after the first audit, for which you need a year, you should be aware of any shortfalls, so you should file within 12 to 8 months. we would say yes, but this does not apply to all claims. Warranties are far more than just the accounts, so we would need more time. Then we have de minimis and basket. So you cannot raise a claim if it's below certain value. And then they also had idea that the claims should be above some aggregate value, which you call basket. So you can have either one big claims or two big claims or a few smaller claims, which should be above the basket. So let's say you have 10 million euro transaction, the minimus will be 10,000 euros, basket will be something like 50,000. So you can have one claim of 50 or 5 claims of 10. And then the reason behind this is that you don't want to invoke court procedures or arbitrations for peanuts, as lawyers cost. There are also fees to be paid, and this is why we have these rules. But this also comes from ES. We have tipping the basket and deductible basket. So in US, they would say, okay, you reach the basket, you can have me liable at the court, but I won't be liable for the full basket, just for the excess. In Europe, we are more inclined to tipping the basket, that we get the full amount. Personally, I think the tipping the basket is more fair approach, as let's assume you have 57 euro claim. If you would apply deductible basket, you would end up with 7,000 euros claim, and it would not be worth it going into litigation. So basically, with deductible basket, it's like having a double basket to have incentive to start litigation. Finally, we have cap on all claims. It depends on the deal size. So small and medium-sized deals go up to 100%. They are more often in range of 50 to 75. You would receive for title and capacity the full, but for large deals, they could go as low as 20, 25. We had one transaction now with only 10%. We were asking for the seller, which was institutional. He did not want to provide more than 10%. The reason behind this is that if you take example of the pharmaceutical company we gave before, so let's say some pharmaceutical company's patent on vaccine has been contested. Yes, surely that will affect the price. However, given that such company has at least a dozen of other patents, this will not reduce the price for 100%, and this is why you can accept limitation of 20% unless the company owns one asset, whether it's IP, real estate, or whatever, which in itself has such value. In such case, you would ask for up to 100. Now, when you're in Croatia or in continental Europe as well, but of course we cannot advise you on German or French law, you have to bear in mind that even though the contract has limitations, we have some limitations, are exclusion of liabilities. So we already dealt with one at the start where we said that if the purchaser is aware or should have been aware, it cannot claim from the seller. These limitations reflect the limitations of seller's liability. So willful misconduct and gross negligence cannot be limited. Let's assume the seller had a patent or some license it had to renew. Let's say that the renewal date is after the closing date, but the seller did not prepare everything which was needed, so the purchaser fails to renew timely. This would be grossly negligence, and such limitation of liability, no matter the time, the quantity, or the scope, would not be excluded. Also, very important, maximum amount of liability will not be binding if it's disproportionate with actual damages. So even if you agreed on 20%, if, let's say, there is a factory on one real estate and the company loses a title, even though you agreed on 20%, the courts would say that such cap would not hold it, as it's disproportionate to actual damage the company and consequently the buyer has suffered. Furthermore, liability for material and legal defects cannot be limited if the seller was aware of it, or it could not be unaware of such defect. This also arises from a good faith principle. We have actually here some case law for cap amount. Unfortunately, there is no case law we could find. Here we have some case law. They all relate to cars. It seems that Croatians like cars. So in first case, the seller was a mechanic, and the court said, well, it's not possible that you were not aware that the brakes are not working, so you're liable for breach of contract. Finally, we come to conclusions. So in respect of Croatian law, first things to know is it's irrelevant to make classification of the statements. It doesn't matter whether it's referred as representation or warranty. Whether one party relied on the warranties, it's not decisive factor in applying the remedies. However, due diligence might be of relevance, as the seller shall not be liable for defects which could not be unfamiliar to him, unless the seller provided specific warranty. Difference between warranties and indemnities are important, because if the seller provides indemnities, the purchaser shall more easily inform performance of claim rather than prove breach of warranty and amount of damages. Finally, limitations may undermine warranties. In a way, they become irrelevant, but one has to be careful, as those may be disputed under mandatory provisions of Code of Obligations. Thank you. This is all on our side. Now we will have a look at the questions that were raised, and we'll be happy to address them as they were placed. So just to glide through.
Okay, so there's only one question for me, so Moimir can maybe in peace review all the questions that he got while he was holding his presentation. It was from anonymous attendee. I think it was questioned 2 times. So the question is, what are the trends with CCA cases for unfair trading and competition practices? Has there been an increase in such cases over recent months? Well, first of all, to be honest, that is not strictly connected to this subject, but I will answer this question. I guess that the person asking this question actually thinks about the fact that in March 2021, the Croatian Parliament adopted the final proposal for the new law on unfair trading practices. Of course, as all of us dealing with these issues, usually I went through this proposal. Of course, there is a now extended list of actions that constitute unfair trading practices. So I believe that once the act is enacted, that the CCA agency will actually have more work on this part than they had up to now. And if I recall well, they also have some new actions they are allowed to to do in relation to these unfair trade practices. So for now, I think it was the same as in 2020, maybe a bit more by the end of the year, but in 2021, actually, we all do expect these processes to be increased in the number of. And that is the only question we have from this Q&A part. So maybe now, Moimir, if you had time to review,
Yes,
you can take over.
Thank you. So there are a couple of questions. Some are brief and some require more elaboration. So I will quickly reply to the brief ones first. Going from the back, to what extent can you exclude the statutory rules of liability? You can, as we said, you can. So if general period is 5 years, you can short it to any period of time. How common is to see the warranties insurance? Actually, it's still rare in Croatia. We only had one such case that we are aware of at the market. So this is something that still did not took such a big leap in Croatia. Are Croatian warranty limitations seller friendly, especially with respect to capstone liability? Well, it very much depends on the seller. If the seller is not the bank, they are more friendly than if the seller comes from some other industry. This is our experience. The banks are extremely tense with in respect of NPLs, for instance, where they sell. Usually it's the cap is on 10%. In one case, the bank even asked for 5%. We were very surprised. And now the more interesting question. So there is a question: what is the difference between tax indemnity and tax warranty? We actually also had one such case recently, where we had wording of indemnity covering basically tax warranty. And then the question was, so the seller accepted to provide tax indemnity, which was very appreciative to us. You have to take into account in Croatian market that small and mid-sized companies do not always follow international financial reporting standards. Often the salaries are not always put on board. It's not that uncommon to see payments below the table. So this is why it's very important for a buyer to receive tax indemnity. And after the seller accepted to provide tax indemnity, says, okay, but why would you then need a warranty on the exact same matter? The difference, there can always be a subtle difference. In our case, there was a difference that tax warranty was also covering for misdemeanors, which tax indemnity didn't. But the key reason is something else. So we said that for tax indemnity, you need subsequent future event, such as in respect of taxes, is that you had tax audit and that they found the company liable for taxes. But tax audits are fortunately not that often, and it may happen that the company does not, if it's lucky, does not receive a visit from tax authority for many years. On the other hand, if investor is serious company applying international financial reporting standards, and if during the audit they learn that the company actually did not follow the standards, they will want to change it. And then perhaps they would need to restate the financial statements, the accounts. In such case, the numbers could dramatically change. If you would have tax indemnity, the seller would say, well, this was your decision. I didn't provide a warranty. So this is why you need a warranty, that the books were ran in accordance with international financial reporting standards, that despite tax audit, you as a seller may request an adjustment of the purchase price because of not following the rules. Second question, we have seen in some transactions that the beneficiary of indemnity is a target company and not the purchaser. That is correct. So in principle, under English law, it should be said that if I recall, the Third Parties Act was enacted in 1999 in England, and English lawyers do not like that third party could rely on representations or warranties or indemnities in this case, or if it's not a party to a contract. But in Croatia and continental legal systems, we do not have such problem. So this is something that is perfectly fine. So now the question is, what is in its interest? So in seller's interest, it might be to pay to the company rather than to a buyer, because theoretically, if there was certain breach, if the seller indemnifies the company, it could well say that the company should not have claims against former management, as the seller reimbursed the company. On the other hand, the buyer will have interest to receive the money rather than the company, as in such case it will receive the funds directly and not indirectly through the target company. But actually it's also a tax question, because if the seller pays the company, such payment would be perceived as income, which would be taxable. So the buyer will want to receive the money in order not to lose. In Croatia, corporate tax income is 18%, so not to be forced to pay taxes on basically the suffered loss. What is of relevance is whether the seller is selling 100% or only part of the package. So if the buyer is acquiring, let's say 70%, 75, 50%, 25%, then the seller will, it's in seller's interest will be to pay the company, because if it paid the buyer, then the company will be at loss, and maybe the company will face illiquidity problems. So if you have more sellers, we would always, as a buyer, be expected that the seller will want to pay the company, and then the tax issue could be dealt differently. Let's see if there is anything else. I think this is it. I think we have 5 more minutes left. So if there are any other questions, or if anyone thinks we did not answer all the questions. Before, there was a question on the Croatian market. I can also, is there a possibility to send us a presentation by email? Yes, this is one very good question. Of course, you will receive it. We will send it over if you opted that we may contact you because of GDPR rules. So anyone who would like to receive a presentation, please email us, unless you have opted that you accept to share details.
Should also say, Moima, we will be putting a video of this presentation up on our website, so everyone can access it through that. But yeah, you have the email addresses of Moima, Barbara, and Mariana on your screen now. So if you want a copy of the slides, please email them. I'm sure they'll be happy to oblige. Okay, Moima, do you want to wait a couple of minutes to see if any other questions come in, or shall we?
Sorry, actually, I think that maybe Moimir, when you open this Q&A part, there's this answered part. 2 questions went there, so I'm not sure if you have seen them. It's one is about Croatian market.
This is what I answered. So it was whether Croatian market is seller or buyer. Actually, Croatian companies are unfortunately, Croatian economy is unfortunately poor, so we don't have many strong companies. This is why usually it's a target company. So we have sellers selling companies in Croatia. There were a few big investments. So in 2014, Agrokor acquired Mercator, leading Slovenian retail chain. Atlantic Group also acquired Droga Kolinska from Slovenia and Serbia. Agrokor, former Agrokor also acquired. So, but these in Serbia, so in Bosnia. So these are all, let's say, regional. The good news for Croatia is that we now have some very strong IT companies. We have Infobip, which is expected to go on New York Stock Exchange soon. Probably next year. And it's possible that such companies will be looking at targets elsewhere, not just within the region. In the past, we had a very strong pharmaceutical company, Pliva, which Mariana told you about its hostile takeover, with Bar Pharmaceuticals as a white knight saving management of Pliva. So Pliva acquired a company in US some 20 years ago. I'm not aware of any other Croatian company making huge investments abroad, so it's definitely a seller's market.
Okay, Moima, we have had another question coming in. It's quite a long one, so I don't know if you want to take a stab at that.
All right, just what we have seen so far as a practical very much of the legal. Yes, so in my personal view, as I said, we have warranties. So representations should not be, if we have in contract representation, we should perceive it as a warranty. And if it's a warranty, this is something that we would qualify as, if you remember that catalog from 410 section of Obligations Act at number 3. So this is something that the seller specifically warranted as an item. There are not, to our knowledge, as much core practice on it. We have core practice where there was sell as is. So a sale of a car where the seller says, well, this is the car I'm selling as is, basically with excluding the limitations. If there was a warranty that the car does not possess certain qualities, the part is contracted, we strongly believe that the general rules should abide. Of course, you could go around it with contract. So if you say that you cannot terminate for instance, this is what happens in contracts. The seller will always limit a right of a buyer to terminate the contracts, but you would always be entitled to damages. So if certain warranty is breached, you will have right to claim the damages, and in our view, you should not have problem in accomplishing such claim, provided that you will be successful in defending that the warranty has been breached indeed. And as I said, sometimes this will be difficult. So for instance, if there is a breach on, if the company does not own IP license, well, that's very simple to prove. You cannot produce a medicine or vaccine, and of course the company has losses. But for warranty on accounts, this may be very difficult. Also, Very important to note. The sellers are not keen to provide general disclosures, but very specific ones. So if you noted something in due diligence and you did not ask for specific warranty, you may basically be left out of the protection which would otherwise arise from the law. I hope this was helpful.
Excellent. Well, look, with that, I think we should close there. But if there are any further questions or anything slightly more complex, it requires a more deliberation, please email them to Moime. Well, sorry to speak on your behalf, Moime, but I'm sure you'll be glad of it. Look, huge thank you to Moime, Barbara, and Mariana, the Osterman team, for a wonderful presentation, really enlightening. Huge thanks to you in the audience for joining us. So we will close there. But good day.